We're back on Politics Nation with a new twist in the Trayvon Martin case. Today, the judge revealed her husband works at the same law firm as an attorney who just got hired as a TV analyst for this very case. The potential conflict may lead George Zimmerman's attorney to ask for a new judge. It's just one indication. This will be a very dramatic time leading to trial. Joining me is Catherine Cryer, a former judge, prosecutor, and journalist. She's also the author of Patriot Acts, and John Burris, an experienced criminal defense attorney. Thank you both for your time and for joining me tonight. Yeah. Let me start with you, Catherine. Is it significant that this judge might be forced to step down from the case?
Well, the way you phrased it, yes, that would be significant if she was forced to step down, although since there really haven't been proceedings yet, it's not that it would be a problem. But I don't see that an analyst in her husband's law firm is a conflict that would require this judge to recuse herself, unless you can show some more influential relationship between the judge and that person, or through the conduit of her husband. I don't think this is a recusable circumstance.
All right, let me go to you, John. The lawyers have kind of staked out where they are. You have the special prosecutor, and you have Mr. Amara. Mr. Amara, Mark Amara has practiced law almost 30 years. He's handled high-profile trials, represented serial killer, local radio celebrity, gang members, known for a calm, savvy litigation style. And almost from the beginning, he's shown sympathy to the family. He's not come off as amateur-like as his predecessors in handling this case. He's tried to kind of be cool and calm and respectful. You have, on the other hand, the prosecutor who has been very compassionate, raising the pain of the parents, the loss of life. So we're seeing their styles, and they're playing to potential jurors and the public.
Well, I see that, but the lawyer approach, the defense lawyer's approach, is a sound one. I think it's highly professional, and what he really needs to do is calm everybody down. What he really wants to do is to hone in on his particular strategy, keep all the distractions away, and make sure everyone stays focused on the case. It's appropriate for the prosecution to do what she's doing, but wants to say, we got all this emotion, we have all this passion, but when you look at these facts, on these facts, you will see that my client has a good self-defense, and he wants to keep everyone to keep an open mind toward that and to calm things down, and also to suggest he doesn't have any kind of negativism toward the family. He's really just doing his professional job as a lawyer, and that's the approach he's really going to take, and it's a good approach.
Catherine, a lot happened this week. How do you see this week? What do you think we are looking at, and what do you predict?
Well, I certainly think that we're going to have to take a deep breath, because both the prosecution and the defense want a little time, particularly the defense. They obviously need time to prepare, but as Omara has said, I want things to simmer down before I seek the bail, bond hearing, before we move forward. Let it get a little more dispassionate. He also has been very good about saying there may be real problems with stand your ground laws, but in fact, I believe my client can avail himself of the law as it stands. So it's clear that he's going to concede. There could be some problems with the statute. That's very, very smart. But at the same time, if it applies to my client, then he should be able to assert that particular defense. Wise strategy on his part.
Well, John, let's look at what both the prosecutor, Ms. Corey, and what Amara said about the possible use of stand your ground.
If stand your ground becomes an issue, we fight it if we believe it's the right thing to do. So if it becomes an issue in this case, we will fight that affirmative defense.
That statute has some troublesome portions to it, and we are now, I think, going to have discussions and conversations about that as a state. But right now, it's the law of Florida, and it's the law that's going to have impact on this case.
So that's where both of them are. How do you read that, John?
Well, what I think what the defense lawyer is saying is, look, there's a lot of public discussion about this law now, and it may get amended. There's a lot of issues that sometimes hasn't been applied properly in other places. But in this case, he is going to apply it. Make no mistake about it. The mistake here is not about the law itself. It's how you apply the facts of this particular case. He has problems with those facts, but he is definitely going to make this approach. The prosecution knows she's going to have to defend this particular issue, and she thinks she's going to be successful because of the chasing and all that. But at the same time, this is going to be a major element in the case. And more importantly, even if they lose, the defense lawyer knows he's going to get another bite out of the apple at some later point at the trial. So he knows he's going to get 2 shots at self-defense in this case.
Yeah, well, but we saw in the affidavit that was filed by the prosecution on probable cause that sort of the roadmap on where she's going in terms of a prosecution. One, Zimmerman confronted Martin and a struggle ensued. Martin was profiled by George Zimmerman, and Trayvon's mother reviewed the 911 calls and identified the voice crying for help as Trayvon Martin's voice. All of this, Catherine, would indicate that if, in fact, this is how the prosecution is proceeding, that would be problematic to have a stand-your-ground defense to these.
Absolutely. In a stand-your-ground defense, you need to be acting lawfully. And then, someone else, an aggressor, comes at you and you fear serious bodily harm or death, and you respond accordingly. The facts that the prosecution is asserting, and we will, of course, see at the time of trial, is that, in fact, he was the aggressor. He was threatening Trayvon Martin. Trayvon Martin was the one crying for help. And so she certainly was confident in pursuing second-degree murder, that she had the facts to support that. And we will see as the case unfolds.
That's right. We will see. Catherine Cryer, John Burris, thanks to you both, and have a nice weekend.
You too.
Thank you.
Coming up, the long road to justice. That's next.